I'm not going.
Recording in progress.
No period is prescribed. In that
page 11.
Yes. No. Police. Emergent police by speed force. Speak, sir. Next date of hearing. 15th. Call on is 15th. Next.
1 to 39.
Same order. 1 to 39, same order. Next.
Item 40, WPC 2259 of 2025.
40.
Item 40.
40.
Your Lordship, I have filed 2 applications. One for modification. I have tried to intervene in the matter. Your Lordship is to allow that petition if my Lord would hear provide.
I will exclude item number 5.
5.
Item number 5.
Notice.
No, Lord. They have a complaint party to your Lordship's order. But the rest part of the order has not been complied. So let them comply within 1 or 2 days. Here they have complied.
Now notice we have said
It will be complied in total.
that's what. Notice has gone. Next date you make this submission. We can see.
My Lord, I have filed Your Lordship's order had passed an order, my Lord.
Double 259.
The doers. Very innocuous order, it seems, Your Lordship.
1 to That's fine.
Order is already passed.
Your Lordship has passed an order. Disposed of. But I have come as for modification of the order and by your intervention because I am the affected party by your Lordship's order.
How you are affected? What was the order? Show the order. What is the order?
First one and last order. It's that is there, my Lord, annex to 16178.
16178.
14/8/2025. Your Lordship may kindly not there, my Lord.
No.
Your Lordship may have a look. WPCL.
Innocuous order.
That is very innocuous order.
If innocuous order, where is the intervention?
My Lord, there where I am. I am a party contesting for this one plot, my Lord. I am the owner in possession. He is the encroacher. He has constructed a house there and is trying to encroach upon my place. And
You are assisting, man.
No. So also my place. So accordingly, there are several writ petitions I have given, my Lord. If your Lordship, I may get back to
Similar matters.
similar matters where we are parties. He was noticed.
In this, you were not made a party.
I was not made a party, neither I was noticed. Your Lordship.
Who appears for the writ petitioner? Nobody is there, no?
Yes, I am there,
Yes.
I am for the petitioner.
He says that you are an encroacher.
Subsequently, my lord, after passing of this order, my lord, prior to that, my lord, my Lord Senior has filed an application for demarcation. That demarcation order has been passed in presence of both the parties. Since they are saying that I am the encroacher, so BTA, they are trying to evict me. Subsequently, I have approached this honorable court, and your lordship has directed, without following due process of law, the petitioner may not. Thereafter, order has been passed in review applications where the demarcation order has been passed. That demarcation will be done in presence of both the parties. That
Review
was
means,
the order.
review means in my petition a review, not here, my lord.
Correct. Even that, then justice is done to you. That will be done
Now,
in your
what the
presence.
problem is this order, if a lordship's order, definitely honorable court also said Justice Panigre, it was before my lord's Panigre, Justice Panigre, he also said due process of law.
Correct.
Now, this order is staring at me. So what I pray, my lord, your lordship may recall the order. If your lordship so desires, may hear us afresh.
No, where is the question? It's an innocuous order. There is no innocuous order will not be recalled. We will say anything to be done shall be after notice to you.
Yes.
There we are litigating.
That is
There will, in fact, only day before yesterday, my lord, this mutation petitioner was allowed in my favor, whereas his was rejected. So these are the things, these are not before
So
subject.
then we will say, in implementing our order, you will be heard in the matter.
Yes. Yes.
All contentions we are killing.
Because
Your
it-
this is in-
I was not made a party here. There I had made him a party.
All right. Application in I number 16176, I number 16178. 6. There are two A's, na?
My lord, 6 is for modification
16176 of 2025
and 16178 for intervention.
is for modification of the order dated 14/8/2025, whereby the subject petition was disposed of by an innocuous observation. First of all, IA number 16178 of 2025 seeks intervention so that the companion application also can be processed. First, third, senior advocate Mr. Sarangi appearing for the intervener and the counsel appearing for the parties, other parties to the petition, including AG. First up. Next paragraph. While implementing the order,
Recording stopped.
I will not grant intervention at all. We have made it only clarity. I will not grant intervention at all. We have made it only clarity. Order on a yes. Below that you write. All right. Put the name of the intervener also. Full cost statement and name of the intervener.
Item 41, WBC 35877 of 2025.
It's ready for hearing, my lord. We have filed counter. That's my
Counter to be filed within
filed, already filed, already
filed?
filed. Yes.
ready.
My lord, let's fix a date so that the petitioner will come and
Call up to 2 weeks to enable counsel for the petitioner to come and yes.
Item 42, review petition 38 of 2026.
No, sir, I have filed my objection to the limitation and for the opposite partner one.
This is the review.
Yes,
Who is for petitioner?
it's not there.
All right. Same order. Next.
Item 43, review petition 233 of 2025.
Item 42, I'm sorry.
42. Yes, you are for review. You are for the petitioner.
Yes,
Ah.
review petition.
Review petitioner.
Delay is of around 120 days, Your Lordship.
Again 20. 120 days.
That is to be condoned, Your Lordship.
That will condone provided you give some amount to him.
Your Lordship, here has what has happened.
You say he has to argue the matter. Otherwise, he will.
No,
say,
I am the review petitioner. I'll say why I filed it at belated.
Now,
No, we are condoning delay. But late payment.
it is a charitable institution, Your Lordship. It's a school, Your Lordship. It is a school run for the benefit of the. It's a religious institute for educational purpose, Your Lordship. It's a trust. Your Lordship, as Your Lordship pleases.
Lord, sir, there is, you also kindly see the petition for
Application,
conversation. No ground. No ground, my lords, why he has come late. Lord, he has to show the sufficient cause why he is not a party for the court below.
Okay.
Lord, he in the review application.
In IN number 80 of 2020, supported by an affidavit, which is that IA for condonation of delay?
Plus 79 of
2026.
No ground, nothing, Lord.
Affidavit seeks condonation of delay in moving the review petition. First of the same is supported by affidavit. First, objections are filed by which
It is 79 of 26. I'm
by
sorry, Your
the
Lordship.
writ petitioner
I guess 79 of 26.
to the said application. First of counsel for the
Haphazard petition, Lord. No date, nothing else. A petition is itself.
petitioner vehemently opposes the condonation of killing. First of. Next paragraph. In para 3 of the counter objections filed by the
OP number 1.
OP number 1 to the review petition, condonation of delay.
My lords.
Condonation of delay. At the para 3, certain spaces are kept blank, and therefore it reflects that there is no due application of the mind while drafting the objection. First, be that as it may.
Objection.
Correct. Having
Not
heard-
objection, not a petition.
Huh?
Delay petition while drafting.
When you come to para 3,
Yes, my lords. I have quoted
read
a.
2 marks
Yes, it is his quotation.
his quotation.
Yes, my lords. In the petition itself, he has quoted. This is I will reproduced before lords.
Next one. Having heard learned counsel for the parties and having perused the application and objections, this court is of considered view that delay needs to be condoned, subject to condition. Some reasonable amount, which is payment of reasonable amount to the objector. First, if delay is not condoned, justice may not be done to the petitioner, who happens to be which society?
It's
Trust, my lord.
it's a trust, Your Lordship.
Public trust.
It's Saraswat Secondary School.
Religious trust.
It's a religious trust, and it is employing. It's a trust for the educational purpose, you know. So it's a religious trust. The one being is
You're not answering the question.
Saraswat Secondary School Education and Vocational Studies.
You're not answering both. Both you do not know the trust law.
Trust.
Yes. Is it a trust falling under section 92 of CPC, or is it a trust under the Trust Act 1885? Therefore, I preluded that both of you do not know trust law.
I'm sorry, I could not assist. I'll send it.
Register doing this. First, in the above circumstances, delay application is allowed and delay condoned, subject to a condition that the review petitioner shall pay a sum of rupees 2,500 to the OP number 1.
Yes.
OP number 1 within 2 weeks. Failing week, the application shall be deemed to have been rejected, and as a consequence, the review petition call after 2 weeks.
The writ petition may be tagged along with the review petition.
To place the petition papers along with the review petition.
Item
There
43.
is no such procedure here. When a review petition is filed, The procedure in Karnataka state
Yes.
is that of the main case paper.
They has to, because he has filed
Without that, you will not be able.
another petition he has filed to recall the order, and another writ application has been filed. Those writ applications called for in the another writ application. So present application has been tagged with the other petition he has filed. He is not the counsel. Other counsel engaged. The file application recall. All these matters are pending.
Next.
Item number 41. Item number 41.
41.
Yes, Lordship.
Where were you?
I'm coming.
Yes.
My Lord, I'm filing a memo, no instruction memo. I'm filing the no instruction memo. I'm from the petitioner, and petitioner has no instruction to proceed. Not instructed to me to proceed further in this case.
Wait, you have filed Wakala.
Yes, Lordship.
You have filed the petition.
Yes, Lordship.
What instruction you need?
Now he has restricted that no instruction. He is not receiving my call, my Lord.
Let him not receive. But there is a petition. You have already made the averments. You have produced the document. Argue the matter. Where is it? It's not for cross-examination.
What is the development? I have no.
We do not know. Whatever is not development. Now, if you argue, well and good. No instruction is no ground. That is the ground only when you need instruction for cross-examining other side for other things. Not this. You have drafted the petition.
Yes, Lord.
Is it not?
Upon instruction by the petition.
If you want to withdraw, you withdraw the petition.
No, that is instruction. No. I don't have that.
Therefore, you are bound to argue. You are engaged to argue by making payment to you. You can't say no instruction. Or you should say one instruction is necessary. What instruction you wanted to press before the court, that instruction is not available. You can't say no instruction. What is meant by that? No, nothing like that.
Then you will also keep it to.
Same order.
Item 43, review petition 200-2025.
Yes.
43, I'm seeking for a Passover.
Passover. How Passover? We have another bench, na? Let us see. In the meanwhile, it becomes a Passover.
Item 44, Contempt 7 of 2026.
May I please, my lord.
Yes.
My lord, there is no compliance of the order.
What was the order?
My lord, 13/2/2026, have a glance to that order. Order number 2.
University shall pay petition having been favored the surely issues quashing the impugned order made by extraordinary university coupled with a writ of mandamus to the university to issue order of compassionate appointment or the extent that rehabilitation within a period of 3 weeks and report compliance to the Registrar General of the ruling university shall pay ₹1,000 per day to the petitioner in such order is. Yes, brother. Is there any appeal and stay?
No stay. Only appeal has been filed.
It is asked to him, kindly sit down. Sit down, sit down. Before you need to, you should not interfere.
My lord,
Other junior starts following you. Yes.
I have already submitted before your lordship, and your lordship has mentioned in your lordship's order that the part compliance of the payment of the cost of 1 lakh and 1,000 rupees per day has already been paid to him. But the other part of the order is in challenge before the Honorable Division Bench of the
stay has been
Chief
granted?
Justice. No. The contemplation, the petition has been heard and notice has been issued, and the contempt and the petitioners or respondents there have been served with the copies and they have appeared. And that is the situation now. Thereafter, it has not been listed for various other reasons. I did not mention before.
We can't do that. There is an order. We have fixed a time period for compliance. You have to get the stay or you have to comply with the order, subject to outcome of the appeal.
What I was submitting before your lordship, my prayer was that, in fact, I cannot advise my clients to defy your lordship's order. But the only thing is, once we fail in the writ application, everything is to be paid right from the day of your lordship's order.
Correct.
So, in that view of the matter, if your lordship gives me some breathing space, then
No, last time also you took time.
no, that is why I said that I had already submitted before lordship, and lordship has, your lordship may kindly look at your lordship's order.
Yes.
Wherein I have stated that, and those who
In challenge. That's all.
in regard to that, I have given 2 documents where payments have been made.
How much money you have paid?
1 lakh rupees as cost and 1,000 rupees per day
How much it is?
Till it was compliant, meaning the part of the order was compliant.
Part of the order is compliant means that payment.
Months.
Then remaining every day 1,000 rupees you have to pay.
No, remaining 1,000, I don't dispute that.
So you pay that.
No, that has been paid till this 1 lakh rupees was paid, sir.
Up to what period? When it was? Now how many days have lapsed?
Thereafter, much days.
You pay that and then we'll relieve the. Otherwise you will direct personal presence of the.
In that case, your lordship, I'll bow down to your lordship.
For what order? For the personal presence of the parties?
No, no,
Vice
because,
Chancellor.
no. One thing I'd like to make clear: when I am before your lordship pleading for my client, they need not be present. It's up to your lordship.
If they don't comply with the order, what I should do?
No, it's up to your lordship. I totally leave it on to your lordship. But as regards that particular 1,000 rupees to be paid, as your lordship suggests, that till date, that could be.
Till date, how many? How much? How many days?
That I have not counted.
No counting. From the date of the order.
No, from the date of the order.
Prescribed period.
No, in fact, what I'm trying to put before
up to making payment, you have made that.
Yes, ma'am.
But when thereafter, when did you make that payment?
That I have a document to give next.
We are asking a date.
I passed on to your lordship also. Your lordship.
It's a case of compassionate appointment. Case of compassionate appointment. It is a case of compassionate appointment. You want people to die. The object of compassionate appointment is to ensure that the dependents of the deceased employee do not die of starvation. That is the object.
Yes,
therefore, it should be treated on war footing. We have passed an order.
Yes.
Now, when did you make that payment?
That payment was made on 19/1/26, which I have annexed to my so-called.
How many days are over now? 19/4, 26 over.
Months.
How many days it will be? 19/2, 18/2, 18/3, 18/2 will be 22 because February only
28.
20. So 22 and 23, 19/2, 18 to 1 month, 23 another month, then 19/4 3 months. Now, you pay 90,000 rupees and will you do?
Your lordship.
This court wide order dated 28/10/2025 had granted the following relief to the complainant. First, learned panel counsel, Mr. Patnaik, appearing for contemner. How many contemners?
Contemner one.
Vice Chancellor?
No, the registrar.
Registrar?
The registrar.
The contemner. First contemner submits that. How many contemners are here? Only one.
Only one line.
Submits that. Submits that. Against the said order, writ appeal number
213 of 2026
has been filed after booking delay, and that the division bench has directed issuance of notice on application for condonation of funds. He also adds that a sum of 1 lakh has been paid to the complainant on 19/1/2026. In addition, apart from paying the amount calculated at the rate of rupees 1,000 per day of delay. Now, 3 more months are over and nothing has been done in the matter. First, mere filing of an appeal does not result into suspension of the order whose violation is complained of. First, in the above circumstances, court wanted to a direct personal appearance of contemptor. First one. However, that intent is for the time being postponed, subject to the condition that the contemptor shall pay rupees pay the additional amount for the delay at the rate of rupees 1,000 within 2 weeks, failing which his personal presence may be directed out. You get that money. Let us see. One left item 31 to opposite number 31. 31. Appearance on time for the traffic loss. So let it be taken off.
Sir, he was asking 41, it was absent to 2 weeks after. It has been absent.
No, up to 39 we have directed in this one.
He's asking for item 41.
For 41.
Yes.
41 for variance from status order, there will be
It is for the opposite party. The petitioner came and make a mention before your lordship that he has no instruction to appear in this case.
That's matter.
Yes.
Let us see it of the thing is that he has to seek instruction. Now you are only OP. I am OP intervening.
So we have filed counter.
But he has any interim order is there? Yes,
Interim order is there.
Variance of
So your lordship directed to get the matter listed
next week for my mistake.
to accept.
Call next week.
Your Honor, my number was 2043. VC room was opened bit late. My number is passed. Item number 43, Your Honor.
Yes, sir.
May submit, Your Honor. Item number 43.
43.
Yes, Your Honor.
You are seeking review.
Your Honor.
43.
Preliminary point of materiality here.
Yes, Your Honor.
In fact, content was passed by my lord Aloysius Behra. The said honorable judge is functioning in terms of rule 12 of Odisha.
It has to go before the same judge.
And secondly, other things are also there. You can raise it for that.
No, the review is kindly come to my order.
No, it's not your lordship.
8/9/2025.
No, it's not your lordship.
Is it?
Review is
review
that civil revisions review, which are in fact after the civil revision, they find a repeat sum which is not misconceived. Your lordship dismissed it, but now they are asking review of the civil revisions order.
Therefore, it has to go push this matter before the judge who decided CRP 20 of 2024.
Right.
Yes, Your Honor.
In terms of rule?
Chapter 8, Rule 12 of Odisha High Court rules.
In terms of rule 12 of chapter 8 of Orissa High Court rules. Come on. After securing orders at the hands of Hon'Ble the Chief Justice, if needed.
The same rules is also there in Karnataka.
Yes, definitely. We have also same rule. Whoever decides, he should review that. Yes.
So great.
Unless he is not available,
Yes,
retire.
exactly. So great.
Yeah, go before the same judge. Yes.
Item 45, contempt 386 of 2026.
45, it's a matter relating to rehabilitation assistance. Your lordship's order dated 12/9/2025. Lordship may kindly peruse.
Lordship, last order.
It was your lordship directed.
Same as Biplab Kumar Sahu.
Yes, directed the opposite parties to extend the benefits of regular appointment in favor of the petitioners from their initial date of appointment. On such extension of the benefits of regular appointment, all service and financial benefits as due and admissible shall also be extended in favor of the petitioners. This court affects the opposite party number 3 to complete the entire exercise within a period of 3 months from the date of receipt of this order. My lord, in compliance with your lordship's order, a compliance was filed by the opposite party number 3.
Nature of compliance is?
Annexure A by 3, your lordship may kindly.
A by 3?
My lord. In pursuance of letter number so and so, dated 24/8/2015, the Director Secondary Education Odisha, Bhubaneswar clarified the clarification issued by letter dated 3/7/2024 of the school and mass.
In level 4,
My lord,
cell 1 of the pay matrix of
my lord, with usual DA and allowances as admissible from time to time with effect from the date of regularization. He was appointed as a junior assistant working in a fully aided high school of Baleshwar district.
Scale of pay is 19,900 is extended now.
Yes.
With effect from which date?
Date of regularization is 25/5/2024. Date of initial engagement is 25/5/2018. Because, my lord, it's an
6 months will be well.
My lord, it's an aided institution. So the employees died in the institution, the legal heirs has to be adjusted against the existing vacancy because there the appointing authorities are the management.
You are only approving authority.
My lord. So unless the vacancy comes in that school, he cannot be appointed there. So according to that vacancy, they have got the appointment. If he is a regular employee of a government institution, he can be adjusted somewhere else. But because he is a son of a deceased employee working in an aided institution.
Correct. But the one that the employee,
Yes.
vacancy arises there.
Vacancy arises, my lord. And not against the post of a teacher, a teacher cannot be adjusted there.
My lord, my prayer, my lord, my prayer is not such, lordship. I was appointed, initial appointment is 2018, lordship.
Yes.
And Biplava Sahu case is that from the initial appointment, because there is no rule, has not been changed in 1993 rule, the date of appointment will be the regular appointment, lordship. But they had made this contractual appointment. For that only, Biplava Sahu case was filed before the Hon'Ble Court, and Biplava Sahu case was heard at length. After that, Biplava Sahu case was directed that from the initial date of appointment, he will
should be
regularized and financial benefit will be given to that one. And Biplava Sahu also have got he is also.
After one sentence, you should stop so that judge can apply his mind to what you say.
Yes, sir.
Is it not?
Biplava Sahu case was for that only after 6 years they have given Biplava Sahu. This judgment was Biplava Sahu judgment is that from the date of initial appointment. And your lordship also my case
benefit.
From the date of appointment, initial appointment, my salary, I will be treated as the regular employees, and all these financial benefit will be given to that one. Biplava Sahu have got the financial benefit from the date of appointment. Yes, Lord.
But here, my lord, the initial engagement was on 25/5/2018. 18, my lord.
18.
It is there in the annexure AY3, your lordship may kindly.
25/5/2018.
The initial.
From the initial, there is the compliance of the order.
My lord, here, my lord, by then, my lord, the contractual rule 2013 was in force.
We do not know. There is an order. Order of the
when
court.
the rule was in force.
That would have been the argument when order was being passed. Once order is passed, that argument is not available. Will direct appearance of the parties. Who has to? District education officer.
No, lordship.
Matter is no. Matter is. Lordship may kindly give me a week's time. Call this matter next week. I should come up with better instruction instead of personal appearance. Lordship may call this matter next week.
So last order they submitted that full compliance will be there.
This court not being satisfied about the alleged compliance of the order, wanted to direct personal appearance of OP number?
OP3.
OP3?
Yes, they
Who should do that?
OP3 is the implementing of authority.
OPs,
My lord.
contemners. Contemners. In as much as, though the initial appointment is with effect from 25/5/2018, comma, the regularization has been granted with effect from 19/1/26, no, 25/5/24.
Yes,
25/5/2024,
after 6 years.
which is not a true compliance of letter and spirit of the order in question. First one. At the request of learned EGA to come out with hopefully true compliance, come on. Matter stands adjourned to which date, brother? Adjourned to when we shall sit. First May. First May. First. Next.
46 is the same.
46 also same.
Same, my lord.
Same. Next.
Item 47, content 420/2026.
Hey, Mr. G,
My lord.
order is so clear as he rightly said.
My lord.
With effect from
Yes.
initial.
Yes, the lordship is
The
right.
authorities do
But-
not want to.
But by then, the contractual rule was in force.
That makes no
That's why.
sense because that touches the merits of the matter. That is not available to you. Because
My
matter
lord.
is
Now-
over.
Yes.
Maybe it may be a wrong order, fit for appeal. But as long as you are not appealed, order has to be complied.
Complied with. Your lordship is right.
Yeah, why can't you advise your
I will advise
clients?
them accordingly.
Otherwise, they are testing our patience.
My lord,
This is not the way. Yes.
I will do that.
Please,
my
Your
lord.
Honor.
Yeah.
Item
In this
47.
case, I am appealing for the petitioner and to receive the show cause reply. I pray one time, Lord, I'll file additional affidavit.
You are what? Who are you?
I am the petitioner, my Lord.
Petitioner or contemner? The complainant. Complainant.
Yes, ma'am.
Who is the complainant?
Complaint.
Yeah. Whether compliance is done.
No, they have filed the show cause reply contesting that your lordship order has complied. They have not complied. In this case, the petitioner was acting as guest
What
faculty.
was the order?
Order, your lordship, page 9, your lordship.
11/2024.
Your lordship,
Next or one, kindly
Just
page
a-
9.
page 9. Your lordship is in the order.
1 second, I am reading.
Yes, sir. The petitioner shall be continued with the same terms and conditions during the pendency of the petition. Interim order, your lordship passed. He's a guest faculty, your lordship. Because one year was completed, your lordship still says that in view of the interim order, they may be allowed.
Order shall be kindly read the order.
Yes, ma'am. It is only continued with the same terms and conditions during the pendency of the petition. He was continuing, my lord. That
He
is
is continuing.
continuing.
Your lordship kindly.
She said that classes should be given, which I have explained.
Your lordship kindly consider. As per your lordship's order, they have extended our tenure.
Correct.
But they have not given our classes.
Where
for
is
one-
the direction for giving a same number of classes?
The same number, no classes has been given. Not a single class has not been given.
You are continued
Yes, ma'am.
in employment.
Yes, sir. He is himself.
Other faculties on same order given the classes.
All that, how can we examine in contempt jurisdiction? You take up that issue before the learned single judge. We will reserve liberty to you.
Yes.
On the ground that they have not complied with this order, therefore their defense should be struck off.
Yes, ma'am. That liberty.
All right. Complaint alleges non-compliance of order dated 21/11/2025, whereby the subject with petition was disposed of. First, after service of notice, the contemners having entered appearance through their counsel submitting that the said order has been complied with by continuing the complainant in service as directed. First, the grievance of the complainant that a particular number of classes have not been assigned and therefore there is violation of the order, need not be much examined by this court, in as much as the first what you are complaint alleges violation of 25 non-compliance of interim order dated so and so in pending WPC number 32993 of 2025. That way out. Okay. Last line, what you have written now? Violation of the or said order, comma, need not be examined by this court in as much as such a contention can be taken up by the complainant before the writ court. And he can also seek striking off the defense of the contemner if grounds do exist therefore, on the ground that the interim order has not been complied with. First, next, in the above circumstances, see, the complaint is disposed of with liberty as indicated above.
Item 48, contempt 454 of 2026.
Yes. Your voice is not audible to anybody.
Sorry, madam. It's a contempt application for non-compliance of the order dated 13/10/2025, passed in WPC number 781 of 2024.
To grant compassionate appointment?
Yes, madam.
That has not been granted?
No, madam. So kindly have a glance to the order dated.
All right. Why not complaining? Appeal. Any appeal is fine?
Yes, ma'am.
When the appeal was filed?
It was filed on 18/2/2026.
When the with the delay or without delay?
With delay.
Delay of how many? How many? Did it filed after issuance of contempt notice or before?
No, before. As I remember, it's before contempt notice.
Contempt notice was issued on which day?
On 4/2/2026. 4/2/2026.
4/2/2026.
Yes.
You filed appeal on which day?
And it was filed on 18/2/26, and there was a delay of 97 days.
No, you have filed it after contempt court. The police came to your place with the uniform.
That I have not
It's opponent.
taken stock of.
It was, we directed police notice on 4/2/2026 and police went there. Then you chose to file the appeal on 18/2/2026. It is your right. We will not say more than that.
In fact, this police notice did not reach in time. That was my instructions. But however,
when notice was served? See, when notice was served? If your submission is not true, then you run some risk.
No, I can never dare to make a submission falsehood before.
No, we're not saying. If your submission that the notice was not served in time.
That was my instruction.
That's just
because as an officer of the court, I was
who gave that instruction to you?
It was from the registrar's office.
Registrar's office.
My lords.
Who?
The registrar was in.
Registrar himself gave that.
No, it was the legal cell, the SO legal cell who had informed, and the legal consultant too.
Notice was served.
Mention that. Office mentioned.
Not mentioned. After you filed the appeal on 18/2/2026, what has happened?
Fairly stating, I had made mention putting a mention memo myself, but that mention memo was accepted, but I have not been assigned any date. But however, since in the other case, the Honorable Court had ordered for serving copies, I have served copies of the respondent in the writ. And my instruction to add to that is my instruction was that police notice was served after the day it was supposed to be served.
No, that's all. Whether was it, question is not that. Question is whether notice was served before you filed the appeal.
That I'll have to take instruction or
that we ask.
But I'll have to, I'm not taking stock of that.
Learned the panel counsel appearing for the contemners submits that against the order whose violation is complained of, writ appeal number
405 of 2026
has been filed, albeit with the relay application. First one. Filing of appeal does not automatically result into suspension of the order impugned therein. There is such a provision in CPC. What is that provision? We were CPC 41. Read 41(1). Anybody good in CPC?
My learned friend is checking up the.
There is such a provision, 1976 amendment.
Hold on. Section 41, sir.
Order 41. Can anybody assist the court? The filing of appeal per se does not result into suspension of the order challenged. There is such a provision in 1976.
Order 41, Rule 5.
Rule 5. Rule 5.
What you are saying?
Therein, as has been enacted in Order 41, Rule 5 of CPC 1908 by 1976 amendment. First off, however, as a last chance, a period of how many days? First will be 2 weeks. As a last chance, a period of a reasonable period is granted to the contemners for compliance of the order. First time. Call on. You show this to that court will then take up the matter because of hanging sword.
In fact, I had made a mention
on this matter on. See, in every contempt matter, when notice was ordered, when police took the notice from our court, when it was served on the contemptor, when compliance report is filed, all this should be available in a short format. So tell registry, yes, in the as against that contempt case, serial number so and so, somewhere they should mention notice. Police took the notice, service notice on, compliance report taken. These 4 or 5 columns should be mentioned. Tell your registry. Otherwise, we spend time in this wood.
Your Lordship may kindly say contemners because VC and the registrar both them.
Contemners, you tell them they run risk, some risk.
Definitely, my lords, I have already put their fingers into fire. As I
am just making a ground. We are constructing the prison brick by brick.
No,
so that after we ensure their entry days.
In fact, as an officer of the court, I owe responsibility to the Honorable Court.
Yes.
Item 49, Contempt 974 of 2026.
Yes.
They have not complied
direction of this honorable court. Rather, they have playing mischief, foul game with this honorable court.
What is the order?
The order was
Order dated
Annex of 4.
9/9/2025.
For considering the subject representation at Annexure 6.
Annex of thereafter, your lordship directed, I will file a fresh representation along with the read petition and complete annexures. The annexure 2 of my content petition, I have vouching.
You filed it on which date? You filed the representation on which date?
I filed the representation within 10 days.
Date.
That is.
September 25.
29, 2025. Lordship directed within 10 days, but before that I have filed.
Order is dated?
Order is dated 9/9/2025.
What is the period given?
Period given.
Period for disposal is how much?
How much? 2 months.
No, it is 2 weeks.
Yes, 2 months. 2 months expired on?
2 months expired on
29. That will be 1911.
Yes. 9/11.
How you have given representation on 29?
On 29. But order passed on 9/9.
Order is not from the date you give the representation. 2025. Now what happened?
But they have not considered properly. I have vouching that 1 lakh.
Properly we do not know. Whether consideration has happened?
Yes.
When consideration?
There is a compliance affidavit filed, my lord. Lordship may kindly have a look to the annexure to the compliance affidavit. Compliance affidavit.
19/3/2026.
My lord. 19/3/2026. There is a compliance and they have disposed of the representation given by.
How disposed of? Rejected?
My lord, it is in view of the.
Mechanically they have rejected.
We can look into. This is a contempt court.
The prayer of the petitioner for allowing RSCP scheme.
19/11/2025 to 19/3/2026. 5 months pay cost for the delayed compliance.
My lord,
how many days it will be?
Lordship may kindly.
No.
They have. My lord, they have.
You have prescribed time. What for?
My lord, Lordship is right, but rightly or wrongly.
You should have made an application seeking extension of the period.
Lordship is.
Saying that we have difficulty.
Yes.
There is some fire. There is some flood. We are not in a position.
Lordship is right.
But therefore we are not.
But they have disposed of the matters.
That makes no sense.
Only 4-5 months.
This court said in AMS Namadripa, where there is a direction to dispose of, to do a particular thing in a particular period, if it is done but with delay, there is contempt.
Yes, if delay compliance is a contempt. But I beg apology for the delay caused.
No, that apology will not be sufficient. Lordship. Why he has to come before the court? Then these things happen. The cost you have to pay. Cost 25,000?
No, it's very high, my lord.
Otherwise, which advocate will argue the matter without 25,000?
Yes.
How much generally you charge?
We have disposed of. We have carried out your lordship's order, but it is in.
Therefore,
only 4-5 months delay. It's
4-5 months.
Only
5 months.
Yes. It is only.
And also on last occasion, your lordship directed, if similar situated person under Annexure 4 has been extended their benefit, why the petitioner shall not be extend such benefit and he will be deprived. But they have not complied on the spirit of
that contention you can take up in the separate order. But to pay 2,000 rupees per month.
My lord, Annexure 2 of my content petition, which is pending. They have not taken any. Annexure 2 is pending, my lord.
The subject petition was the subject. case, that is WPC 23717 of 2025, was disposed of by order dated 9/9/2025 with the following observation. See, in the above circumstances, up to shall not be broken for UPVC. The complainant filed his representation on 20 September 2025, and a copy thereof awails at Annexure.
Annexure
A2.
A2. No, 2. Annexure 2.
No. A2 is the complaint.
Annexure A2 is their
complaints.
letter which has purposefully made.
Since no order was passed disposing of the subject representation, this complaint has been filed alleging violation of the court order, which specifically warned against broking delay in compliance. In so many words. First of all. Now, the compliance report has been filed along with a copy of order dated 19/3/2026, whereby the subject representation of the complainant has been rejected. First one. There is compliance of the writ of the court only to the extent of disposal of the representation, as rightly contended by learned AGA is true. First one. However, the compliance is not true compliance in as much as a delay of 5 months has been broken despite warning by the writ court. First off, an apology would not be sufficient. A bare apology would not be sufficient for condoning delay. First off, the complainant, who was the successful party before the writ court, should feel gratified. And that would happen if the contemners are penalized by directing them to how many? Make a payment of rupees 2,000 rupees per month to the complainant. First up. This apart, next one. In the above circumstances, the contemners, how many? How many contemners? Respondent.
Only one.
The contemner.
The director.
Is directed contemner, that is Mr. Birendra Karkara, Director, Secondary Education, Odisha, Bhubaneswar, is directed to remit to the complainant a sum of rupees 10,000 within 2 weeks, failing which he shall appear before the court on the next date of hearing personally. Call this matter on. Give that date. It may be 2 weeks. It will be 2 weeks. Yeah.
Annexure 2 is pending. They have not taken any decision on the Annexure 2.
Anyway, that one they have already taken. Yes, for this, call this matter on. So it's so.
Impact.
Yeah.
Item 50, Contempt 131 of 2026.
My Lord's order dated 25/11/2025, my Lord. This is the matter relating to family pension, my Lord. And one was 25/11/2025.
2025.
Your Lordship has observed that resultantly the read petition is allowed, the opposite party authorities are directed to pass necessary orders, extending the benefit of family pension.
Brother, we are just saying one thing. 10,000 rupees should be paid to you. Okay. We will reserve liberty to you to challenge that order of compliance with all contents. We will not examine whether it is right, wrong, etc.
My lord, RSCP is a scheme which I have completed 30 years.
But
my lord.
in the above circumstances, he is directed to pay a sum of rupees 10,000 to the complainant within 2 weeks. 2 weeks, failing which it is open to the complainant to seek revival of these proceedings. First, the liberty is reserved to the complainant to seek redressal against the rejection of his representation by the some order dated 19/3/2026. Okay. In that connection, all contentions are kept open. This board. Yes. Next.
Item 50, Contempt 1331 of.
My Lord's order dated 25/11/2025.
Correct.
My Lord, Your Lordship observed that resultant the read petition is allowed, the opposite party authorities are directed to pass necessary orders extending the benefit of family pension to the petitioner in accordance with the rules if there is no other legal impediment having regards to the fact that the petitioner is an old lady. Aged about 80 years, necessary order shall be passed as directed. Then, my Lordship passed the order, my Lord, 8/5/2024, and claim of the petitioner for family pension has to be considered in light of the rules and obtained as on date
Mr.
of.
Chi, what happened?
My lord, your lordship also directed me to take steps personally, my lord. Here there is a so cause was by BO, ignoring this also, my lord. But at the time of death, my lord, no rule was there. 81 rule was not there, pension rule.
So no pension was paid to anybody.
My lord, there is a way. A way is that Dimson Prusti's case, my lord, the persons who were died on or before 5/8/88 will get the benefit.
5/8/88.
Lordship, may kindly give me a week or two. Let me call them and
yes, because I have the impression that even earlier pension was paid by the state.
Yes, it was.
Maybe I do not know whether there was.
It was.
Pension was paid. Therefore, pension has to be paid. That is the reason we have made that order.
My lord.
Do something.
It was. Earlier it was there. Lordship, may simply call this matter 2 weeks after, my lord. Let me, because she is a year-old lady. That also.
That's the reason.
Another, my Lord, Subhashini Patnaik, my Lord, which has been referred, my Lord. She has already been granted the pension, my Lord. And her husband died, my Lord, on 1974, 8/1/1974, my Lord. Your Lordship already relied, my Lord.
Yes, second paragraph, we have said that.
My Lord.
Yes. Give me some time, I will call them and.
Matter is reluctantly adjourned to 8/5 for reporting compliance, failing which stringent orders may be passed against the erring officials. Yes. Over.
Your Lordship, permit me to mention item 21.
21.
My lords, the police notice is.
Police notice is issued.
My lords, it has already been complied. I have
21 papers. Learned counsel appearing for the complainant submits that after issuance of contempt notice, the subject order whose violation is complied of has been complied with. First, in view of the above, complaint proceedings are disposed of. Reserving liberty to the petitioner to work out any other remainder of the grievance elsewhere in accordance with law.
Much obliged.
Okay. That will be to the so before when you speak.
WPC 10640 of 2025.
We have said suspension comes to an end with the retirement. The earlier quashment of that one, we don't agree. Okay. And we have referred to one decision which you had argued before us. So that also. That was the case where the revocation of suspension was by order of the authority.
Yes, sir.
But this is revocation because he repeated office.
Yes, sir.
That subtle difference just we have worked out. We said this aspect would be looked into by the tribunal in your way where you have challenged the charge memo itself.
Okay.
We have reserved that liberty. We have requested the tribunal to consider that also. And in the light of that, we have said like this: in the above circumstances, since in part, impugned order of the tribunal is modified to the effect that the suspension of the OP abated when he demitted office on attaining the age of superannuation. What should happen to the claim of OP for treating the suspension period as duty period shall be examined by the tribunal in the pending OA number 2060 of 2025. The tribunal is requested to hear and dispose of the said OA within an outer limit of 3 months. This is the And the proceedings do not abate. We have made one observation.
Yes, Lordship.
Because you very fairly say
Yes.
that proceedings will not abate.
That I'll argue there, you're not.
That's the point. That's right.
Yes.
Item number 2, matter 439 of the
Yes.
My lord, here,
Any urgency?
only notice has to,
Learned AGA is
notice has to go, notice to go.
What is that, Master?
That is regarding the order passed by the Judge Family Court, Hon'Ble, dismissing
You
my.
said that you will make the payment yesterday.
No, because he has also dismissed because the CP proceeding, which was also filed by the husband, that has been dismissed, seeking for degree of divorce.
Issue notice.
Trial court records we call.
Call for LCR, ECR.
Published.
Both.
Item number 3, WPC 17676 of 2023.
Yes, sir.
Mr. Gopal Jain is on online. If I may request, at this point of time, learned AG may conclude the arguments. I'm just requesting.
We don't know. How can you say he will conclude? Let him start.
Rejoin on the next.
Let him continue. Yes. Your first contention yesterday was, again we examined, 1937 lease, 34 lease, and it cannot go beyond years in any circumstance.
That's the third question, my lord. And that has already been lodged no more res integra, beginning from common cause, series of judgments in their case also in an earlier writ petition, which of course has not closed in the cause title. That has to be that earlier with the Chief Justice Pundesan. I'm not,
but that is not the ground on
same
order structure.
No, the issue is, my lord, the crux, your lordship may keep that in mind. Whether there can be any extension, whether it is in the shape of renewal or
to allow somebody to operate for the period for which he could not be able to operate, etc., whatever may be the reason, beyond period 13th August 2021. Your Lordship may kindly note down this date. The last renewal order, which was executed between the parties, the state government in one hand and the petitioner on the other, was for a period of 20 years, which period admittedly expired on 13th of August 2021. Your Lordship, to make this story short, Your Lordship knows that this grant is in the shape of a statutory grant. Everything, my lord, the terms, conditions, and the etc. of the lease
Regulated by the law.
Are regulated by a special statute, and this being within the domain of the Union Parliament to make law. So, my lord, earlier, when the 2001, the last renewal, it was from 34, then valid for a period of 30 years. Then it was, my lord, the provision in the old section 8 of the MMDR Act prior to 12th of January 2015, when, my lord, the country went to the auction regime because of Your Lordship knows Commission, so many scams in Your Lordship state, Orissa, Jharkhand, Goa, Chhattisgarh. So, my lord, that led to the common cause judgment. Justice Local, they styled it as mega bucks that accused scam all over the country, including the present petitioner. I'll come to that. So, what happened, in order to operate a mining, 4 conditions are essential. A mining plan under Section 5 of the Act, the environmental clearance under the, my lord, Environment Protection Act, and the forest clearance under the Forest Conservation Act, and, my lord, the consent to operate under the Water and Air Pollution Act by the State Pollution Control Board. These are the 4 essential statutory documents required to operate, carry on the mining operations. So, my lord, any deficit, any want of any of the documents, my lord, any absence or want of any of these statutorily required documents, my lord, operation beyond this is being treated as illegal mining, which has been defined in the Act. That has also been, my lord, very explicitly dealt with in the common cause judgment. What is it, illegal mining? So, with reference to the cease report and all. So, my lord, in 2004, for the purpose of this, my lord, automatic with the execution of the lease deed, the right doesn't flow. That is to obtaining these statutory compliances. 2004, my lord, the permission environmental clearance was granted for a period of 20 years, which the content that it was valid till the expiry of the lease period.
That the TC clearance is dated?
Dated, my lord, 2004 at annexure. Your Lordship may turn to that also now. 2004 at page annexure 7. They have given a clear copy, typed copy.
22
on page 145. Your Lordship may mark the page.
22/9/2004.
22/9/2024. My lord, that is 2004.
Yes.
This is EC.
Correct.
That is subject to again forest. I'll come to that.
Yes.
Lordship got it.
Yes.
And my lord, it is not for any quantity of minerals. The quantity is also specified. Earlier, the lessee was entitled for production of 1.5 lakh tons, 146 page. Yes, you've got it here. 1.5 lakh tons per annum. 2, it was an enhancement order to 4 million tons per annum. They call it MTPA.
Right. Yeah.
That's you've got it.
Yeah.
So that is again subject to Milord as per the lease agreement in Form K. Earlier the lease agreement was in Form K. Now it is Schedule 7 as per the 2016 rule, because the Act underwent a sea change. So therefore the Mineral Concession Rules 1960 was replaced by a new set of rules called Mineral Concession Rules 2016.
For that, what ground, on what complaint he is before the court?
Complaint is that I was prevented from operating for 5 years. That period should be granted to me.
Let us see the impugned order.
No, let me show. No, I'm not, he's misleading somewhere. Let your lordship may turn to then the next order of 2008. Page number 1.
We are requesting you again.
No, your lordship, this is important. Your lordship may kindly turn to the 2008.
We will look into Mr. Acharya.
Yes.
But again, we are requesting,
madam,
kindly read the impugned order. Impugned order sets the parameters of the lease. We cannot.
No, there is no impugned order.
There is
no. There is no impugned order. Your lordship may look at the prayer. No, your lordship may come to the prayer. That is what? That order has not been challenged. That order is not the impugned order.
To add 5 years.
No, your lordship may kindly turn to the prayer. It's vaguely drafted.
That is add 5 years.
Yes. No, your lordship may kindly turn to the what is the prayer. No order has been challenged. Not even the similar. I am coming why he has not consciously challenged. I am explaining one by one. Overcome, my lord, the writ petition which was dismissed for a further renewal of 10 years.
Yes.
Because the court has given a clear.
Yesterday.
Yes.
Now it matter is that having been discussed.
So it should not, it was not maintainable. Two in common cause also an IA was filed. I'm showing one by one, my lord.
Your second ground is
no impugned order. The order of the deputy director has not been challenged. It was never challenged. Consciously, my lord, also not challenged. Rather,
the first contention of the
yes,
is that the petitioner has not challenged the order
of
2014 order of deputy director of
mines
at Annexure
Annexure 9.
Therefore, without such a challenge,
no, not only that,
here cannot be granted.
Not only that, the Government of India's order also, my lord. The Government of India at Annexure 8.
He adds that same is the case with the Government of India order dated 29/10/2008 at Annexure 8. Yes. What does this order say?
No, my lord, your lordship may kindly, that is the very interesting order. Your lordship may kindly turn to the 2008 order. This is the enhancement from 4 to 15 MTPA, 15 million tons.
That is subject.
Lordship may kindly turn to page 159, Annexure 8. This order is also not under challenge. This is valid till 2014, not till 2021. Lordship may kindly turn to specific conditions. Lord, may I read it? It was for the prayer of the petitioner for
9/10/2008.
Annexure 8
valid up to 2014. Comma. No relief beyond that period.
Environmental. Your lordship may kindly, these 3 documents are very important.
Well,
all the conditions. Let's specific, your lordship got it.
Yeah. Yes.
From 15 millions, above mentioned Thakurani project from Saga Mines for an annual production capacity of 15 million tons It was earlier 4. When 2004 was granted, that was 4 metric ton, a million tons. This was an enhancement order. And this, my lord, EC was granted, was valid up to 2013-14. Your lordship may put me a question here. 2013-14, my lord, means the year, my lord, that has been defined in mineral development rules, my lord. Conservation and development rules, my lord, rule 3U defines what is a year. So that is, my lord, ending with 31st of March 2024. Your lordship may, I'll refer to that rule. Yeah. And the corresponding rule of 2007 is rule 3ZA, small ZA. So I was also asking my officers, why 13-14? Why not a particular date? So they say that year has been defined in the mineral conservation and development rule, which is a part of it, because every lease agreement is subject to compliance with the applicable laws. Yes. So therefore, Milan, environmental clearance is subject to grant of clearance also. It's a conditional thing. Yeah. That's you got it. Yes. Forest clearance, 3 Milan. Environmental clearance is valid up to the year 2013-14. Working of the mine beyond 2014 based on the established reserve shall be commenced only after obtaining prior clearance from the Ministry of Environment and Forest. That's you got it? Yeah. No, right. So basing upon this letter, the Deputy Director Mines, who is enjoined under law, Milord, to prevent illegal mining, he passes, so it's not a suspension of lease. It's a, Milord, your lordship may kindly turn to the impugner. He is authorized under a rule framed under Rule 23C of the Act. I am coming to that. So I was searching for, and that also there is a power which has been conferred in a 2009 notification. I have come with the Gazette notification to prevent illegal mining. So with reference, that is suspension of mining operation. It is not lease, it is mining operation has to be carried out in conformity with law. Not that it's a blanket right, you have been granted with a lease, you with the illegal mining. Yeah. If due to want of any statutory that's right. Next. So therefore he says, referring to this 29/10/2000 letter of the Ministry of Forest and Environment, that this was valid up to 31/3/2014. So therefore you are requested not to carry on any mining operation lest the officer, Milord, so many officers were put behind the bar. It is his bounden duty as an agent and officer of the government to ensure that the mining operation is carried on in accordance with the provisions of the law, statute, applicable laws. Okay. He can't allow someone to carry on the mining operation, yes, notwithstanding the fact that the GC was valid till the year. Definition of year. That's at this context, let me just clarify.
Operation has to take place, as can be carried on, only subject to securing the compliances at various statutes.
Mineral Conservation Rule.
Yes.
This rule incidentally was not in the book, so I brought it, a printed 1988. This is, Milord, this rule is under Section 18 of the MMDR Act.
This is for what purpose you are reading?
Purpose 13-14, that the government order of 2008, this is valid up to 2013-14.
Central government order.
Central government order. So everything, Milord, referred to in the lease agreement year. So that year, Milord, has been defined in 3U, Milord. Let's say about it at page 4. Year means the 12 months period beginning from the first day of April and ending on the 31st. Because every statute also contains that. Because, Milord, there are many ancillary rules. This MMDR Act, for the purpose of carrying out the provisions under the rule-making power, the central government and the state government both have the power of rule-making under Section 13, under Section 18, under Section, Milord. So therefore, the state government in exercise of power under section 23 capital C has also framed a set of rules to streamline the mining operation because the land ultimately belongs to the state. So therefore, in this, there is no ambiguity on this. So now your lordship may kindly turn to the 15 order of the government. Common cause, Millard, thereafter the SA commission came, 15 order, 2015. Lordship, he represented 2015. Annexure 14, Millard. Page 253. Yeah. January 15, 2015. Environment clearance issued by the Ministry of Environment they have referred to 22/9/2004, Millard, the document which I just now showed to your lordship. Millard, this whole letter may be read carefully. This has a reference to the letter dated so-and-so of 3/11/2014 regarding proposal of so-and-so petitioner for permission to mine in terms of EC dated 9/2004. So-and-so was given EC on 22/9/2004 for mining of 4 MTPA iron ore lump from so-and-so hectare of land out of 869 of mining lease area, submitted by above letter that as per EC letter, specific condition number 1, EC is for 20 years and the fresh EC would be required at the time of renewal of mining lease. Further, EC for expansion was issued by letter number dated 29th October 2008. Lordship again, 2008. The EC was issued for production capacity of 15 MTPA subject to the forest clearance. That is reiterated, which is yet to be accorded. The EC was valid up to 30/3/2014. That should have been 31/3, but anyway, the deputy director says 31/3 as expired. So please don't carry on any operation from 1st April 2014. In view of the above, the matter has been examined in the ministry and it has been decided that the permission to mine as per condition of EC of 4 MTPA is approved subject to the permission of Supreme Court because common cause was there. Let's got it, Miller. Yes. Common cause was pending. So there was complete ban on any kind of mining activity. Yes. Large number of criminal cases were filed, entailing imposition of crores and crores of penalties on the violators for non-obtaining of the environmental EC or the FC, whatever, and NOC. And those activities, Millard, in the absence of those statutory documents, the Supreme Court went further to hold these are illegal mining. Penalty was accordingly levied and 900 some odd crore was the penalty on this particular petitioner. So now your lordship subject to the clearance of the Supreme Court. This permission to mine against EC limits was granted by letter dated will be reviewed if required after the final decision by the court. By the final decision of the court on the ownership released issues as brought out by CC and SA Commission. This issues the approval of the competent. Your lordship may kindly turn to the application. What did they do? This order was not challenged. What did they do, Millard? They filed an IA number 42 before the honorable in common cause case for clarification of the order. Your lordship may kindly look to that IA. Yes. Page 255. This is the IA. What is the pleading and what is the prayer? IA number annexure 15. Does it get it?
Yes, yesterday this was read also.
No, I am reading it, Millard. Very interesting. His concerns, is he, Millard, permitted to raise this issue now? That it is submitted paragraph 5 at 261. Submitted present application. Millard, here it was not spelled. It was filed in 2019. But this IA was filed in 15. There was no whisper about the DDM's letter. That's you got it.
Yeah.
No, sorry. They went to the to pray relief on the basis. On the basis of the DDM's letter. They say that we have been prevented for 5 years. But what the Supreme Court has permitted, I'll place that order now, I order. It is there, Milord, I'll that para 5 Milord, that it is submitted. Present application is being filed pursuant to the liberty granted by this court for seeking modification of the order, inasmuch as after the order dated 16/5/14, asked the applicant approach the Ministry of External Affairs seeking appropriate clarification. No, this is important. Sorry,
External Affairs.
Sorry?
MOE. Who is that? External Affairs.
Sorry, Ministry of Environment and Forest. I'm sorry, sir. I'm sorry.
Yes.
That is MOE.
Yes.
So that the earlier environment clearance for MTP iron ore granted by later dated 22/9 is co-terminus with the mining lease and thus valid up to 13/8/21. So you got it?
Yeah.
So not correct. In 15 they revised. 15(1) has accepted the said request of the applicant. It has clarified and reiterated environment clearance is issued by for mining iron ore lump is valid, subsisting till period of the lease. It is nowhere in the order. It has been avoided here. It is nowhere in the 22/9/2014 order. And the lease environment clearance of so and so, a copy of the para 6 Milord. The mining lease, last 3 lines. The mining lease was granted for a period of 20 years with effect from 14/8/21 and is valid and subsisting till 13/8/21. That's got it, Milord.
Yes.
His dates, it is valid till 13/8/2021. Next para, Milord. Para.
This is order of the highest court of the country.
No, this is the IA in the Supreme Court in 2015. They could have prayed there. I have not been prevented for 5 years. No, that is also there. 5 years that prayer is there.
Yeah.
Let's say kindly.
Yeah.
I am placing there. See, Milord, later dated 15/1/15 issued by 263, I am reading, Milord, can operate its mines on the basis of so and so, that is subject to order of the Supreme Court. Forest clearance issued by this so and so, your Lordship may kindly turn to paragraph 8.
It is submitted that in view of the fact that.
Yes, lease is subsisting till 13/8/21. Everywhere he says lease is subsisting, so he should be, Milord, your Lordship.
The court said
the Supreme Court has said that is very important.
Yeah.
Supreme Court order. IA. This one. Milord, this the IA. Yeah, I would have 18. This copy.
Annexure 18. 289.
Annexure
18.
He has filed it, Milord. Yes. Lordship may turn to para, Milord. May I read it, Milord?
Yes.
It's small order.
Yes.
There are 2 IAs, one by this petitioner, other is by Medist. So we are concerned with only
That IA.
paragraphs up to 5.3. 2, Lordship may got it. This court through judgment dated so and so in the lead matter had interpreted that the mining leaseholders who had extracted minerals either without or in excess of environment forest clearance would be liable to deposit the minerals so raised for its value if disposed of with the state government. Owing to a dispute raised by some mining leaseholders, including the petitioner, as to whether in fact they had excavated minerals without requisite clearances, this court referred their cases to the Central Environment Committee for quantification of compensatory dues. The CC submitted a self-speaking report on 8/5/2019. Till 8/5/2009, Milord, this issue was not decided. This order was passed only on, what is the date of the order? This was decided on, Milord, January 2020, after which the state government permitted. This IA was decided on 15th of January 2020. Let's have got it.
Yes.
So during the period from 2001 to 2010-11 has produced such and such tons of excess quantity illegal production of iron ore in violation of the environmental clearance granted by the ministry and is liable to pay 933 crores so and so in terms of the judgment dated 2817 in common cause and the judgment dated 121118 in common cause of so and so. During these proceedings, this court on 22/11/17 constituted a committee consisting of Honorable Justice G.S. Sanghvi and Justice Anil A.R. Dave, retired judges of this court, with a specific mandate to ascertain whether there was any violation of Section 6 of the Mines Minerals so and so Act and Rule 37 of the Mineral Concession Rules. The committee, in volume number 8 of its report, which was taken on record by this court on 24/10/19, examined SMPL's case and
No violation.
there was no violation of either Section 6. But we are not concerned. Section 6 is separate.
Okay.
The transfer of the lease that was allowed. So in the light of these observations contains that it is suffering irreparable. So this doesn't pertain to environmental clearance.
Neither para 4.
Para 4. In the light of these contains that it is suffering irreparable injury and highlights how it has already lost more than 5.5 years and how hardly half a year of its lease period is left. Let's say he is conscious that 21, no right thereafter. Expressing willingness to furnish an undertaking or bank guarantee equivalent to its dues as assessed by the CC, the applicant seeks permission to resume mining operations. Upon notice, the Land Council for the State of Orissa, due strictly in view of the above directions are 5.1 to 5.3, is granted 1 month's time to deposit the amount.
Yes.
File an undertaking to comply with all the rules, regulations, mandatory provisions for carrying out, and after complying with directions 5.1, can resume its mining operation in the leased area
For the
remainder of its lease period. They could have said here that no 5.5 years we are granting till 26. It is not, my lord, permissible. Thereafter, my lord, what happened?
What is meant by remainder of the period?
13/8/21. This order was passed in January 20. His lease period was valid up to 13/8/21 or 31/3/20. I'll show the statutory provision. That has been interpreted. I'm coming one by one. So, my lord, it can be maximum 50 years or last renewal which was made till the expiry of the period of the last renewal. That is the capping. No right thereafter. Section, my lord, rules 12(1) FF, GG and HH will come to play, which is also, my lord, a perimeter area.
1 second. Mr. AG.
Yes.
The apex court directed him to remit certain amount.
That is thing not in dispute. That might have been
For what period it is remitted?
1,100 some odd crore for that period, 1 to 11.
What for what period?
Period is specified here, my lord.
Yeah.
101, he carried illegal operation. 1 to 2, 10 to 11 has produced so and so.
No.
It is there, my lord. Yes. The CC report. My lord, para 2. Para 2 of the order.
You don't change.
Page 290. Para 2.
No, that report you have read now.
That report has been extracted here.
933 crore plus the 60 lakh 70,689.
Yes.
Okay.
So Supreme Court directed, subject to depositing this amount, he may be permitted to resume the operation till the leftover period. Remember,
Leftover period is mentioned in para 4.
para 4, Mila.
Para 4 says,
Para 4 he
half
says
years.
that it has, yes, half years of his lease period is left.
5.5 years is left. That is the leftover.
No, Mila, 5.5 years and how hardly half a year of its lease period.
Read again, read. Let us read together so that others
It has
will.
already lost more than 5.5 years.
Yes.
And how hardly half a year of its lease period, not half year, that would be 1 year and 8 months, is incorrect submission. So they state in the IA that it is valid till 13/8/21. So therefore, Supreme Court says leased area for the remainder of its lease period. Lease period is no dispute, my lord, is till 13/8/2021. There is no dispute on that. That is not the issue. Issue is, my lord, whether he can be given any right beyond 31,821.
Beyond 50 years or 31,
whichever is latter. Language is latter. Your Lordship, I am coming to that provision. The whole section is not there in the book, section 8. Lordship may peruse that. It would be clear. Earlier, my lord, old section 8. The unamended section, when this renewal was granted in 2001, this was the provision. Your Lordship can have a glance at section 8. It was 30 years, then for the renewal, 20 years, Lordship may, periods for which leases may be granted, Your Lordship may, the old provision and the new provision after 12th of January 2015.
This is a
similar page, Your Lordship, at 7, Your Lordship would find. Periods for which mining leases may be granted. Now that would be section 8, capital A.
Shall not exceed 30 years.
30 years. No, then Your Lordship may kindly come. Provided that the minimum period of which shall not be less than 20 years.
Minimum 20 years it should be.
20 years there.
30.
So he was granted year 30, not exactly one Raja of Keonjhar was granted in 34. That mining area has been subsequently transferred, etc., to the private limited company and all. Provided minimum period for which any mining, my lord, annexure 2, I will show Your Lordship the initial grant.
All this section rule says it, section says it.
Yes.
20 years.
No, here, my lord, there was
30 years maximum.
30 years, no, thereafter also it can be further period of 20 years.
It can.
Subsection 3, my lord, that was inserted in 99. A mining lease may be renewed for a period not exceeding 20 years. This was omitted. That's got it. 3, my lord. It was substituted. Notwithstanding anything contained in subsection 2, my lord, that's 2.
Which page you are reading?
I am reading at page 7. The state government is of the opinion, page 7, my lord.
Is of the opinion that the
opinion
development it is
that in the interest of mineral development it is necessary so to do. It may, for reasons to be recorded, authorize the renewal of a mining lease in respect of minerals not specified in Part A and Part B. This is in C, Part C, not A.
Renewal up to 20 years.
For a further period, not exceeding 20 years in A. So, my lord, again also that was permissible. That is, my lord, Rule 21 of the MC rules. So that was, my lord, before expiry of one year from the date of expiry, he will make an application for a renewal. Suppose the state
renewal is also possible.
It was until 15 January 15.
Till 2015 amendment.
15 amendment. My lord, this entire section was substituted by the 2015 amendment because the nation was suffering because of this illegal, etc. So to secure the revenue and also for the proper utilization of the national resources and to translate Article 39 into reality. So, my lord, they came off with this amendment in 2015, which is, my lord, considered as an epoch-making amendment in mining law, no right after 50 years. And for captive, it was till, my lord, 31/3/30, and for non-captive, it was till 31/3/2020, or, my lord, the whichever is latter. Your Lordship may now come to the directly statutory provision which was prevailing in 2021. Now this section 8 which I read, that was governing, there was now that is
we are reading now amended
8A,
new regime.
New regime, 8A, period of blood.
Yes.
Now this is, my lord, the 50% of the state's that comes from the mining sources, and all of us, my lord, are depending upon this. And there were, my lord, your lordship would be surprised. Day before we won a very remarkable mining case. Around 12,000 crores were stayed by this court for 4 years. Production and dispatch, Chief Justice's judgment. It's a very, I was delivered day before. So the provisions, and I'm carefully reading it.
Yes.
The provisions of this section shall apply to minerals other than those in Part A and Part B. Your Lordship was yesterday putting this, so I also got confused. That is C, and entry number 6. Regulation. On and from the date of commencement of the Mines and Minerals Development Amendment Act 2015, on and from, let's make it from, all mining leases shall be granted for the period of 50 years. There is nothing like first renewal, second renewal. Like this period, people have enjoyed for 100 years. There are leases in Orissa also, those who have been enjoying from 1912, 13, like this. All those Rajas, your Lordship, during the British era, because iron ore was not in focus in those days. So all mining leases granted, subsection, before the commencement of
subsection
3.
No, subsection 2 is prospective in operation.
Prospective, Milord. That's
correct. Leases to be granted.
Yes, that has been dealt with in 5 and 6. I'm reading, Milord. 1 by
3 you are coming.
So, Milord, directly all those 30 years, 20 years, all these things are abolished now. Only
yes. 1 by 1 we are going.
Yes.
Subsection 2 says this contemplates leases to be granted hereafter.
Right.
Then I am not to subsection 3, which contemplates leases have already been granted.
Mining granted before the.
That's what. All mining leases granted before the commencement of 2015 shall be deemed to have been granted for a period of.
Let's suppose I am giving an example. Suppose a person.
Granted.
That's correct.
It is granted for 100 years. It becomes 50 years.
Yes.
If it is granted for
100
20
years,
years,
it can be.
No.
It is 30.
One
like,
example to understand the logic.
Right.
Taking you to the extremes of the situation.
No, your Lordship is right.
If it is 100 years,
right,
it will be 50 years.
50 years.
If it is for 10 months,
it
will be 50 years.
Your Lordship is right. I was giving, suppose somebody has been granted in 2012. So that would be also 50 years. But after this date, commencement, everything, not only by this grant, by the mercy of the government, or etc., you come and take. Not like this. So it is through the process of. Now, Milord, it is to be the highest bidder will come. So on the expiry of the lease period, the lease shall be put up for auction.
This is a largest, state largest.
Right.
Therefore, by auction is the mode of business.
That's correct.
Next point.
The safest transparent mode.
Next point.
Provided that nothing contained in this section
will not be
shall
applicable.
Taking an advance action.
Even before the lease expires, state can go for auction. Next point.
What is the provision? I'll come to that.
Yeah.
Notwithstanding anything contained in subsection 2, 3, and 4.
Section 4.
The period of lease
granted before
the date of commencement of the Mines so Amendment Act, where mineral is used for captive purpose. Suppose captive means somebody has a plant. He has taken
himself will consume it.
That is captive. Right.
This is what?
Shall be. This is non-captive. Non-captive.
Not non-captive.
Shall be extended and be deemed to have been extended
up to a
period ending on 30 March 2030. That was not granted. Thereafter, if he wishes to take it for his captive use, you will go for the same process. Auction. Nothing.
So 5 is also not applicable. Because he is not for captive.
No, we are concerned with 6.
Subsection
6. This is the Milord, this subsection 6 has been interpreted in common cause by 3 judgments of our High Court, 3 division benches, Milord. Chief Justice Javeri, Chief Justice Chak, and incidentally, I was the lawyer, the same argument was advanced by me for the petitioner. It was repealed, Milord, negated by the High Court. The same thing. I had also lost 3 years or 4 years. I was praying that it is not due to my fault. It is due to the inaction or the default of the government officer. I should be granted this period.
Let us see.
Notwithstanding anything, JDL, I'm going one by. Your Lordship, let it be clear on law first. What is his right after August 2021?
Correct.
Whether any right can be granted by the state now or by the court for that matter. Not doing anything contained in subsection 2, 3 and subsection 4. The period of lease granted before the date of commencement in the Mines and Minerals Amendment Act, where the mineral is used for other than captive purpose, shall be extended and be deemed to have been extended up to a period ending on 31st March 2020 with effect from the date of expiry of the period of renewal last made or
till the
completion of the renewal
period. Then further,
if any, or for the period of the period from the date of grant of such lease, whichever is latter. 13/8/21 is the latter date. 13/8/21.
No.
That is the yes, my lord.
No.
Lord, your lordship may again read it.
Yes.
With effect from the date of expiry of the period of renewal last made, my lord, 31st March 2020, one eventuality. Lordship got it.
Yes.
Period of 50 years is sacrosanct or till 31st March 2020?
No, not sacrosanct, because the subsection begins with Henry the
Henry
notwithstanding.
Yes.
Ignore the above.
And also, the lordship was correct.
An island province.
Yes, yes. No, below the four contingencies. What are the effect of this? That has been discussed. It has four logical conclusions. Four conclusions. Number one conclusion, have been extended up to period ending on 31st March shall be deemed to by virtue of a legal fiction. It is up to 31st March 2020 with effect from the date of expiry of the period of renewal last made or till the completion of the renewal period, if any.
If any.
Or a period of 50 years from the date of grant of lease.
Whichever is later.
Latter.
Yeah.
So latter date is 13/8/21, my lord.
No.
Suppose, my lord, he says it is 13/8/21. So where is question now?
No, yes. We are interpreting the section only for the limited purpose.
No, that has been interpreted, my lord, in plethora of judgments now, in Supreme Court.
Then we need not spend more time on this.
So that's directly let us come.
Yes.
Your lordship, the common cause case. Supreme Court judgment, I will come from that.
Yeah.
No, but there is no doubt. Let us not have any.
We have.
Yes. Then common cause. No. Common cause. Para 37.
To our mind.
No, your lordship, it is my duty, my lord, to clarify. Court is making a query, my lord. It's my bounden duty to answer and clarify each and every doubt. There can't be a just adjudication.
Yes, Mr. Acharya, graciously, we agree. Our impression of subsection 6
yes.
is whichever is later.
Yes.
May be beyond 50 years also.
Beyond? Yes.
Years.
No, your lordship is correct. Suppose here in this case, his date is 21. It is now, my lord, 64 years. It may be beyond. Your lordship is correct.
Then we need not go to judgment.
No, lordship got it, my lord. Suppose he was granted in 34.
He got it, but you got it.
Suppose somebody has got for 70 years, but the last renewal, 20 years or 10 years, whatever, was made, my lord, say in 2014. For 20 years. It is still 24.
In other words,
yes.
Since subsection 6 begins with the Henry VIII clause,
right,
we have to ignore all other provisions above and come to a conclusion where one of the circumstances can be, depending upon the tenure of the lease, it can far exceed 50 years.
Lordship is correct, my lord. There is no that.
Then
is
we
what,
need not spend much time on the rulings.
Let me
rulings. We are in agreement with you. No, both are in agreement.
No, para 37. If your lordship would permit, then I'll just.
What for? See, to convince us, you have to use the judgment.
That's no.
If we are agreeing with you.
No, lordship.
Still you want to?
I'm so grateful. I'm so grateful. Yes. Now your lordship may kindly come to para 37 of the judgment may be marked. That has also been quoted in the earlier Sarah Mines case filed by him, which is pending in Supreme Court. The same judgment, it is a very well discussed judgment. I am passing on 2 copies. 5 writ petitions were analogously hard. Your Lordship may look at the same thing, it should have been fairly disclosed here. Same point. I'm entitled to a renewal. Court says you have no right beyond. Here I may forget one thing. Let's speak kindly. As per the old day, what would happen? The period expired in August 21, 13th of August. What would happen to it? Now the statute says, four things. Either 50 years, capping is for non-captive 31/3/2020, or till the period of last renewal. Your Lordship is correct in that event. It may exceed also 50 years because of the non-obstante clause. It overrides. 50 years may be the capping period, but if somebody has got the commencement of the amending provision, so he may get that. Yeah. Suppose, my lord, somebody has got a renewal in 13 for 20 years. Period would be 23. As in this case, my lord, Lordship got it, my lord. Period 13-20 years, that would be 33. He will continue up to 33. So that benefit has been given by the legislature for an existing grantee as on the date of commencement of the act to enjoy that period of renewal till its expiry, which he has.
To put it shortly,
yes,
2015 amendment,
yes,
does not curtail the agreed tenure.
Yes, of course. It doesn't, my lord, destroy the right which has already accrued to someone till the expiry period of the grant. The Lordship is correct, I bow down. So now your Lordship may come to the earlier Sarda judgment which is now pending.
What proposition you want to cite this?
No, my lord, this 8A, interpretation, and he has no right after 13(8), no renewal even can be granted. No renewal. Paragraph. Lordship may kindly 3-4, my lord, a very interesting judgment, this one. My lord, para 70. The starting point of the present litigation
what was the prayer in this petition?
To grant further period of 10 years, renewal, to make another renewal years.
But that is not the case here.
No, it is correlated. Why it is interpreted? The court says that you have no right even after 21, we can, against the statute, we can grant any period beyond the last renewal. In view of 8A6, I am referring this judgment for the limited purpose of 8A subsection 6, not for other purpose. The starting point, this your Lordship may, it would be profitable. Litigation is the lease deed itself executed on 14th August 2001. Whatever may have happened prior, including the orders of this court and the compromise decree, the rights of the parties got crystallized only in the said lease deed dated 14th August 2001. If one carefully peruses that document, it is seen that it is between the government on the one hand and SL so-and-so on the other, under Rule 39 of the MC Rules 1960. That is for transfer again, that was in favor of Sarvamine. The document is itself titled Renewal of Mining Lease, and the period is clearly specified as 14/8/2001 to 13/8/2021. This document does not have preamble clauses. It makes no reference to the compromise deed. It clearly states term 20 year is next ensuing. As far as rights of renewal are concerned, clause 3 of the part 8 of Form K under the title Covenants of the State Government states, mining lease is renewable in terms of the provisions of the Act and the rules made thereunder. It is plain, therefore, that the right of renewal would be subject to the provisions of the MMDR Act, MC rules in force of renewal. In other words, there was no promise held out in the said lease deed of any renewal, irrespective of the statutory provisions. In fact, given the settled legal position, there could possibly not have been any such promise held out. That on a plain reading of the lease deed dated 14th August, there is nothing in it which holds out an assurance to the lessee, notwithstanding the provisions of MMDR Act and the MC rules, renewal would take place in terms of the orders passed on 91. There were two judgments of the High Court, even from the letter dated 2001 of the government. It is clear that a second renewal of the mining lease has been granted 20 years. There is no doubt that the entire exercise has been done in terms of MMDR Act and the MC Rules 1960. Mining lease in Form K makes this position abundantly clear. Your Lordship may now come to.
But that was
No, this is, I am reading.
Extension
Para
years.
Milord, para 78. Para 78. Para 77 and 78. Milord, if your Lordship would permit, I will read it from 76. Para 74 is also equally important. Yes, you got it. 76 in common cause.
Yeah.
Now I was referring to it. Your Lordship can refer here. The common cause has been dealt here because this 8A6 has been interpreted. Your Lordship may kindly bear with me. I'm sorry. In common cause, occasion to interpret section 8A as inserted by 2015 Amendment Acts which came into force on 12 January. The dispute between the parties before the court was crystallized in para 23 as on that. There is a serious dispute between the rival parties with reference to the interpretation of sections 8A3, 8A5 and 8A6 of MMDR Act. Whilst the contention of the Learned Counsel appearing for the petitioner common cause is that the benefit of subsection 3, 5 and 6 of 8A will extend only to such mining leases as were subsisting on the date of introduction of the amendment, it is the contention of the Learned Counsel representing the leaseholders. Above postulation at the hands of the Learned Counsel for the non-applicants is wholly misconceived, result in the misreading of so-and-so. Having analyzed the SOR of the bill, the Supreme Court explained as on that. From a perusal of the extract reproduced above, it is apparent insertion of section 8A into the MMDR Act was to address the hardship faced by the leaseholders besides other reasons due to the second and subsequent applications for renewal remaining unattended in the hands of the state government. The instant amendment introduced to uniform original grant period of 50 years for all mining leaseholders. It also excluded renewals after the expiry of the original lease period. Accordingly, no renewal application can now be filed after 12/1/2015 under subsection 5(6) of 8A. In our view, such leaseholders who had moved applications for renewal of non-captive would be entitled to continue up to 31/3/30 or 31/3/2020. The object and reason for the amendment to MMDR Act at remedying the position which emerged from the existed hitherto. Therefore, the above view, my lord, I am not, your lordship may now turn to para 78. I mean, this last 4 lines may be important also. They say, it is therefore apparent, my lord, page 50. It is therefore apparent, let's yes, para 77, last 5 and 6. It is therefore apparent that subsection 5 and 6 of section 8A of the amended act are aimed at situations for renewal validly mail has remained unattended. Therefore, for no fault of the leaseholder, subjected to an arbitrary prejudice. It needs to be clarified that since an application for renewal cannot be filed after 12/1/15, application as would be treated as having been validly made or to have been made before 12/1/15. We're of the view that out of 3 contingencies under subsections 5 and 6 referred to above, the first of the contingencies positively pertains to a situation applications validly made were pending without any final decision, so and so. Because disinterested to continue the, therefore, logically the words with effect from the date of expiry should relate to an expired lease prior to so and so. Thereafter, in para 37, conclusion of the Supreme Court was summarized. Relevant to the case on the hand, 37.1, 30. Milord, I was going to place this paragraph 37, but however it has been. Milord, a leaseholder would have a subsisting mining lease if the period of the original grant was still in currency on 12/1/15. Leaseholder whose original lease has since expired will still have a subsisting lease if the original lease having renewed, the renewal period was still in currency on 12/1/15. Lordship was putting this question. If it was renewal period was still 21, so 31/3/2020 is not the end date. It will continue up to 31/8/21. So such leaseholder would entitle to the benefit of Section 8A of the amended Act. Consequent upon the amendment of so provides for three contingencies where benefits have been extended to the leaseholders whose lease period had earlier been extended by a renewal. Firstly, for a leaseholder whose renewal period had expired before 12/1/15 and the leaseholder had moved an application for renewal at least 12 months before the leaseholder's existing so and so, the lease period has not been considered and rejected. The lease period would stand extended up to 31/3/30 or 31/3/20 in case of captive, non-captive. Additionally, a leaseholder whose period of renewal would expire after 12/1/15 but before 31/3/30 or 20, the lease period would stand extended up to such period. Secondly, where the renewal of the already extends to a period beyond 31/3/20, your Lordship was asking me this question. If it has been renewed beyond 31/3/30 for captive and 31/3/20, in case of captive, non-captive, the lease period of such leaseholders would continue up to the actual period contemplated by the
beyond 50 years also.
Oh, Lordship is correct. So that is no, Milord, they are not. They say that from 14 to the Supreme Court's order, we should be given another 5.5 years. So, Milord, that has been, Milord, your Lordship may, para 79, Lordship may, they have discussed everything. There can't be, Milord, para 82, Milord, is important. The AP Christian medical case has been relied upon. There can't be any relief beyond the statute. According to this, a claim for refund, Lordship may turn to next paragraph. Yet the question, I am, Milord, starting from page 55. Yet the question is whether it is possible for me. Yes.
Mr. Acharya.
Yes, Lord.
Makes an interesting reading is true, but not much relevant to our case.
No, I am directly coming to the judgment on this issue. I swore this because of their conduct, not for. I am coming to the direct judgments now. So 20th May 21 passed by. I swore the Supreme Court order of 20, permitting him for the remainder period. They say it was hardly 1.5 years. So therefore, till the remainder period, which should be. So Supreme Court, the Environment Department says it is subject to clearance. It arbitrarily expired on 31/3/14. There was no scope for them. Grant of lease doesn't mean automatically he will commence the mining operation.
Subject to condition.
Subject to condition. If it was lacking, the poor fellow cannot, officers of the government cannot permit him. Ultimately, they would be answerable to the authorities. That why did you permit? That's under. So, Milord, consequently, 83, Milord, this court upholds the order passed by the rejecting the prayer of the petitioner so and so, all applications pending so and so, petitioners for renewal of the mining lease beyond 13th August 2021. Milord, they have discussed that beyond 13th August 2021, he has no right. Because, Milord, now at this juncture, your Lordship may kindly turn to Rule 12(1) GG and HH. What would happen? The law will come to play. It doesn't come within force majeure theory, Milord. Your Lordship knows that it is none of the clauses of the force majeure is applicable. That is also force majeure, Milord, has been defined. If your Lordship would turn to what is force majeure, that is akin to 12(1) FF of the current rule, 2016 rule, which was a part of the lease deed. Your Lordship would find it at page in the covenant, annexure 6, Milord. Annexure at page 134. Milord, this is in parameteria. This is the old Form K, which corresponds to Schedule 7. This is Part 9 of the Form K. General provisions starts from page 133. It's a part of the lease deed. But failure on the part of the lessee to fulfill any
Paragraph 4 you are reading.
Paragraph 4 shall not give the central government any claim against the lessee to or be deemed a breach of this lease insofar as such failure is considered by the state government to arise from force measure. And if through force measure the fulfillment by the lessees of any of the terms and conditions of this lease be delayed, the period of such delay shall be added to the period fixed by this lease. In this clause, this is important. The expression force measure means act of God, war, insurrection, riot, civil commotion, strike, earthquake, tide, storm, etc., and any other happening which he could not reasonably prevent or control. I was arguing the similar clause in JDL Mines. That whether it can come within, there is a old judgment of our High Court also, I think Justice Sachi Acharya. So it doesn't come. So
read 1967 Supreme Court.
1967 Supreme Court. Your Lordship is correct. So now, Your Lordship, I know
to what you are saying.
is an authority. And so Your Lordship is a living encyclopedia of the judgment. I am aware of it. But still then, Milord, I feel it, I have my duty. I am not, Milord, here to let Your Lordship know that what is the power of a writ court in 226 to exercise to grant relief against the statute. I have not done that. Law is so well settled that Your Lordship's vast knowledge in both constitutional law and all those things, and pure common sense also, many things can be deduced. So law, Milord, directly two judgments I am coming of this court, two division bench judgments, which also went to Supreme Court, got confirmed. Milord, Your Lordship may, I have given that in the counter affidavit. It is, if you look at the counter affidavit. RP Sao, that went to
for the proposition.
This one, this period cannot be granted. I was praying, Milord, I had lost 4 years because they did not grant me the environmental clearance or pollution control. Same argument, Milord. What argument is being advanced by the other side that this period was not in my control, so therefore I should be granted. I have lost 5 years. I had also lost, I was a minor, JDL Mines. RP Sao also the same case, same the proposition. Lordship may directly come to the JDL judgment first, RP Sao judgment. And another judgment, Milord.
This court,
Milord.
This court.
Two division bench judgment.
Do they refer to 1967 Supreme Court?
Let me check. I have forgotten.
If they have not referred, we need not spend much time on that.
67, Milord. Force measure.
Yes. Force have applied.
Yes.
Even in a case which does not, even in a mining case, it was a mining case.
Yes.
A mining case which does not perfect fit into force majeure.
Right.
The principle based upon its relief is granted to the lessee.
Right.
On the force majeure is extended to non-force majeure circumstance. Specifically saying this case is not covered by force majeure, still on that principle itself we grant this relief.
No, it has never been granted in a mining matter. So far, Milord, not a single judgment.
Kindly do not misspeak, because a judge is saying that 1967 Supreme Court has considered this aspect.
So, Milord, 1967, this law was not there. This amendment was not there.
That terminology is considered by...
No, it is... No, Your Lordship, force measure provided this. Force measure doesn't mean that in the absence of a statutorily required document, she would be allowed to operate the query. Government, Milord, says it is subject. Supreme Court also doesn't grant this. Milord, a party was there. Penalty was imposed. He had not paid the fees.
Which is that the 1967 Supreme Court. Give it. Yeah, it is admits. Read one provision, one paragraph. then it will throw light. We may not make statements at the bar, even the judges should not make, but we are making a guarded statement after reading that judgment.
Milord,
For a moment,
Milord, I'll examine that.
Supreme Court.
I can examine, but so far, all those, no, I'll go through that. Certainly, Milord, I have to be educated also. But the question is, force majeure is on a different, in a mining, our own High Court has also dealt with the force majeure in the mining case, directly on a mining case. So here also, Milord, this force majeure theory has been argued in Supreme Court in common cause. Common cause is the latest judgment of 17. So that force majeure, I had also argued it has been dealt with. Maybe on judgment, your Lordship may kindly see the latest view. Force majeure, your Lordship may kindly come to this judgment in RP Saab.
Your first proposition, Mr. Acharya.
Yes.
It is not a case of force majeure. We are in agreement.
Right.
Matter does not end there. The highest court of the country has extended certain benefits of leases of mining, even in cases which do not fit into the idea of force majeure, on the very same principle. That we are telling you.
No,
We are in agreement
that
with you.
may be, but relief cannot be granted beyond this period.
That was the argument. That was the argument which now you are saying. That was the argument before the apex court.
Please such, Milord, may please have one by one. This is recent judgment of 19 of our High Court. So the lessee in respect of Guwahati iron ore mines of 365 hectares, page 45
of the
counter efficient. And this went up to Supreme Court, both the cases. Attend finality.
Finality in the sense SLP dismissed or
maybe its application also, Milord, murder. I am aware of Puneha Lal and Coded Distillery, but even that is not been also in Livni. High Court order has become final. So far, this aspect is concerned. With the lessee in respect of Guwahati iron ore mine.
Which paragraph?
Para 2. Fact, your Lordship. The petitioner who is the lessee in respect of Guwahati iron ore mines over an area of 365 hectares in village Guwahati, Kodapuda, so under Barbil Tahsil in subdivision of Keonjhar district has filed the present writ petition seeking restoration of the lost period. Same prayer, Milord, lost period. From 2013 to 14, 10 months and 20 days, and from 23/5/2015 to 10/4/18, that is 34 months, 19 days, thus total period of 45 months and 9 days, for which the lessee could not operate its mines due to interruptions, disruptions, cost which was beyond the control of the lessee. This para 4 is this, which was control of the lessee, more particularly when such disruptions were caused mainly by the act of commission on the part of the authorities of the state government. The same argument, Pilar. Here, state government. He further submitted various legal proceedings are pending before this court and the Honorable Supreme Court in respect of the mines in question. The substratum of challenge of the petitioner, the writ petition is the decision dated 22/9 of the state government communicated to the petitioner 30 to allocate mining lease in question in favor of Orissa mineral exploration so and so, reference so and so. This force measure 3.1. Emphasis is laid on Form K of Mineral Concession Rule Clause 4, of which is placed reliance for better appreciation, and whereas let's have got it, Milord. Facts Clause 4 is quoted here and below. Failure on the part of the lease, etc. Emphasis supplied by the petitioner on this lease delay. Period of such delay shall be added. He was arguing this delay period should be added to my lease period. It is contended that the petitioner was not allowed to carry on mining so 45 months in all. Regarding made representation which was not yet paid heed of, government decided to lease out the mines in question to OMCL, state-owned corporation. Action of the government is contrary to the provision of section 17A which is reproduced below reservation of area. Since there is no approval as yet, therefore replied. Further contention of Mr. Gupta, by communication, the special secretary through pay order so and so were not concerned. In support of his contention, he is placed on the judgment of the Supreme Court in Begra Singh versus State of UP, wherein the Honorable Supreme Court in Para 7 held agenda. Having regard, counsel for the state and private respondent, we are satisfied petitioner deserves to be allowed. Ordinary rule of litigation, rights of the parties stand crystallized on the date of commencement of the litigation, etc., etc. Milord, the whole third party interest has been created, etc. Then he relies upon this Dharambir case of Delhi High Court. Further, one counsel for the petitioner submitted that his submissions get support from the reply affidavit filed by the state government in common cause case, which is relevant consideration. Taking into consideration so and so, the entire contention has been reproduced here. Then your lordship may kindly come to in an alternative argument, para 10.
Yeah.
Unless the lease shall be determined so and so, not bound to deliver. In view of such provision, the decision of the he was praying that after the expiry also I am entitled to 6 months, which is akin to 12 GG. Para 5 of Form K is now 12.1 GG. After the expiry of the lease period, he is entitled to 6 months period as a moratorium to dispose of the extracted minerals. If he doesn't do, then 12.1 HH, which is akin to Para 6 of the Form K, he is listing that it would be deemed to be the property of the state after expiry of a period of 30 days. So likewise, my lord, all those properties we have put to auction by the OMC after the expiry of the lease period, some 21, 20. Before this court also a batch of cases that are being heard separately, that we should be given as a force majeure clause. Mr. So many senior counsels, the court didn't agree, I was arguing. All, my lord, as 7, 8 minus. So beyond, my lord, the period was 31/3/2020. 6 months expired on 30th September 2020. Thereafter, 1 month, 31/10/2020, no right thereafter. It shall be deemed to be the property. Will be getting around 15,000-16,000 crore revenue to the Odisha Mining Corporation. We have already put it to auction. So there was an extension by the High Court on consent of the State's Advocate General, which I objected. He could not have made such a concession against statute. And it is not binding on the state on a concession of law. He can't. On fact, he may say. But if the statute restricts the period on 30th September 2020, there cannot be any extension by the High Court also beyond that period. It was extended up to December by a judicial order. So anyway, that period had expired.
One small question we are asking.
Yes, Mila.
There is a lease for 50 years.
Yes.
All essentials which you have mentioned are complied with. Forest clearance, environmental clearance, and other clearances. Everything. The collector says, you shall not operate the lease. And it is for about 5 years. He was prevented from operating the lease. You mean to say that lessee cannot get an order at the hands of writ court?
No, that's not my submission. No. I said dangerous submission. Why should I? am conscious. I'm not. That is not the case here. 14, the deputy director suspended. He did not challenge that order. 15, the government of India says subject to order of Supreme Court. He doesn't challenge that order. Rather, he goes in common cause by filing an IA in the disposed of case. Says that kindly allow me till the remainder period. Then he comes for a renewal, which was rejected with a filing.
Renewal is rejected.
So Supreme Court also doesn't permit. Supreme Court is hearing. Common cause is still, there is an MA which has been converted as a MA 14 or something like that. Though the common cause case is still pending, he can do forum shopping. One application there in 19 that you allow me. In 19 he could have prayed that. When the deputy director passed the order in 14, and Government of India in 15, in 9 says that it is valid till 2014. 31(3), there was no clearance. And wrong did the Deputy Director commit. Milord, your Lordship is giving a situation where despite the existence of all statutory clearances, a mischievous officer puts an innocent lessee into trouble. That's not the scenario situation here. A person who does not have the requisite clearance comes before the court and makes a prayer. You grant me. Can the court grant this relief? A dangerous proposition, Milord, in my humble opinion. Too dangerous. That will open floodgate now. 3 petitions have been dismissed on this same argument. And all the other case, Milord, incidentally, I was the lawyer for the petitioner in JDL case. I was very vociferously arguing this, canvassing this point. It's a force measure. It's not my fault. Environmental clearance, it remained pending with the government for 4 years despite the recommendation by the authority. I can't suffer for that period. Court says no. Beyond this, you have no right. And relief certainly, Milord, cannot be granted contrary to the provision of the statute. Any scenario may arise. Your Lordship is correct. Courts are not, Milord, powerless. Your Lordship is correct. 226 is all pervasive. There are, Milord, note, here your Lordship knows the Odisha scenario. 70,000 crores of scam in mining. A poor officer, and that too the government is directing you carry out, go and make the check, give the report. So many people were behind the bar, 200 persons, Milord, many government officers, many 3-4 deputy directors are facing the vigilance prosecution out of job. So what wrong? And 14 order was never challenged, not even in this petition. Not even in this petition. And if at all, Milord, in 24 the writ petition has been filed. In 19, when the IA was filed in Supreme Court, they could have said, we have lost 5 years to your wife, 2021 till August, kindly grant us another 5.5 years. Is it permissible? Supreme Court in common cause says no. So Milord, I am not in essence, does not say that the courts are very, your Lordship is emboldened with 226, more powerful than Article 32. Common cause was a 32 proceeding. Your Lordship is sitting in a very vast and wide jurisdiction with power. Any direction doesn't even mere infraction or abolition of the fundamental rights. Yes. I'm not on that. I'm not disputing that the court is bereft of any power to adjudicate an issue. 14 order, 15 order, Government of India says it is valid 14. Is there any challenge to that order? It says subject to order of the court's permission, Supreme Court. Is there any order? They go and beg the mercy of the Supreme Court rather and say that we have only hardly 1 year left. Kindly allow us to resume the operation. Government permits. Can you come by 2? Again, as your Lordship pleases, I'm feeling fine anytime. 2, but it may continue up to 3. There is a reference at 3. I can continue. Up to whatever point you want to. Yes. Or some other day, if you want, there is no urgency, Milord. Some other day, there is no urgency. Any day, convenient to my Lord, I'll make myself available. It's an interesting case also. Interesting case also. Any day. On 30th, all right. 30th? Yeah. As you Lordship please. No, 30th. Can it be on 29th? 29th. Before we get
not 29.
Whatever you want to do it. We don't know. Whatever papers are with us, we consider. He has raised a very valid point. He says, not a case of force majeure. And 67 Supreme Court did not consider the idea of force majeure as a enacted under these rules.
29.
That's what he is saying. Yes.
Lord, we'll answer that. I have only one request. Lord, 29th, I'm assisting the Supreme Court as an amicus. Today, 28th, if my lords can kindly have
28th is a holiday in High Court.
Unfortunately, we are not sitting that day. That there is a holiday.
Then, so, please provide me a High Court calendar and is a Supreme Court. Jain Saab, I'll send you a High Court calendar.
Any other date you say?
Thank you for the courtesy. My Lord, your Lordship can hear my learned friend on 29th and I can be accommodated on the next day.
No, 29th also I have difficulty. No, Mr. Jain, there is another matter in Supreme Court for me too. say that same common catch. So 29th Milord, I will also be occupied.
Yes, choose someday.
30th.
Mr. Jain, will it be all right? 30th will be all right.
30th also. Just
Whatever date is convenient to my learned.
Date will not, but I may virtually do it if I am in Delhi. On 29th, 30th Milord, it is showing. There is a fraud insurance case to Justice Amanullah hearing. It is continuing, all India ramification. The first week of May, any date, Milord.
No, we should not forget that.
No, your lordship's memory is, Milord.
No, there is now it is failing.
It is faster than AI.
So,
1st May?
1st May?
1st May, Mahanadi Tribunal. Mr. Jain, I have a schedule also.
Okay.
So, Milord, 1st May.
That's what.
Now, let it be.
Let it be on
subject to his convenience also.
Let it be on 30th so that we sort of, as your lordship says, have the continuity and the momentum. Let it be on 30th.
All right.
30th, Milord, I mean,
you are held up.
29th and 30th.
Yes, choose someday.
Milord, 5th May.
We have posted 11 cases, perhaps.
11. 4th May. 4th May.
4th May also we have posted cases.
4th. 6th May. Any day, that day up to 7th. Milord, your lordship as a part matter can take it up. 7th May.
10 cases.
Milord, as a part matter, it can put it at the...
Milord, for momentum and continuity, kindly have it slightly earlier. Otherwise, Milord, the whole purpose of having back-to-back hearings.
What? It was being hard and reserved for judgment also.
Held up even in the...
I have to also see my schedule, Mr. Jain.
We'll have it on...
I didn't say no, but I'm only saying let's not unreasonably stretch it. Not to try. We can try.
My lord has a computer memory.
Working day.
It's more than 5 MB.
2nd May is working day.
Second.
Saturday. Mr. Jain, 2nd May, it will be complete.
Well, 2nd May is a Saturday.
It is a working day.
No, that's Mahanadi.
2nd May.
That I am also held up in a couple of Mahanadi tribunal dispute is that day, Chhattisgarh and Odisha.
Second of this.
Saturday they are taking off.
On
Milord, 4th May or 5th, any date, Milord, any date from 4th to 8, let him give.
Yes, sir, Mr. Jain. Now, ball is in your court.
Milord, ball is always in my learned friend's court. He dictates.
No. I am you are opposing. 4 to 8, any day you take.
You choose someday.
Is they not the council's convenience? It's the court's convenience.
We are always here. Even if Cobra comes here, we cannot go away.
Milord, then let's take 4th May and make a...
4th May?
Yes.
Okay.
Grateful.
Well, that's what we will complete. This is a specially assigned matter. Put it at the top of the... Yeah, to make it on the top of the list. You complete that.
Yes, Milord.
That day, so that the rest of the matters we can. Because this is specially assigned matter by Honorable Chief Justice.
No. It's also a specially assigned matter.
Yes,
because Chief Justice recused here.